What evidence proves trade secret misappropriation? Imagine someone taking your secret recipe or business plan and using it to compete against you. How do you prove they stole or used your trade secret? That's where evidence comes into play. First, you need to show that the information is truly a trade secret. This means it has real value because it's not common knowledge. It could be a special formula, customer list, or unique process. You also need proof that you took reasonable steps to keep it secret, like signing confidentiality agreements or limiting access. Next, you must prove that someone acquired the secret through improper means. This includes theft, hacking into your systems, bribery, or spying. For example, if an employee used a computer to copy files without permission or someone bribed an insider to share information, those are strong clues. Digital forensics, emails, or security logs can reveal unauthorized access or transfers. Then, it's important to show that the accused knew or should have known the information was a secret and that they obtained it unlawfully. If a former employee leaves and takes confidential data, but they signed a non-disclosure agreement, that's a key piece of evidence. It shows they were aware of their obligation and still chose to act against it. You also need to demonstrate that the secret was used or shared without your approval. This can be shown through documents, emails, or witness testimony. For instance, if your secret recipe appears in a competitor's product or your customer list is shared publicly, that points to misuse. Sometimes, showing economic harm helps strengthen your case. If you lost sales or market share because your secret was leaked or stolen, evidence of these damages can support your claim. This might include financial records or market analysis. Defense claims might argue that the secret was independently developed or reverse-engineered legally. To counter this, you need evidence that your secret couldn't have been discovered without improper means. For example, if your process is highly complex and not reverse-engineerable, that supports your case. In cases involving former employees, courts may accept that their memory alone can be enough to prove misappropriation, especially if they had access to the secret and breached confidentiality. To gather this evidence, companies review employment contracts, conduct forensic analysis of computers and emails, interview witnesses, and document security measures. Acting quickly is vital because once a secret becomes public, it loses its legal protection. If you can prove that someone wrongfully acquired, used, or disclosed your trade secret without permission, you may be entitled to stop them through court orders, recover damages, or even claim profits they gained. In the end, proving trade secret misappropriation is about showing that your secret was valuable, protected, and unlawfully taken or used by someone who knew better. Clear evidence like documents, digital records, and witness testimony makes your case stronger and helps protect your business.